Thank you, Mr. Shima. Will counsel in 126-555 please come forward? Sherri, you may argue whenever ready.
May it please the court. Again, appellee John Schutt appearing by counsel Jada Kerr. This is a case, the Schutt Trust owns a home in Prairie Village, Kansas. The trust and Sherri Foster had a written lease agreement that commenced on November 1 of 2018 to July 31st of 2019. This lease had a late fee provision that $20 for each day was due for rents that remained unpaid after the due date, which is the first of the month. Ms. Foster lived at the rental property from November 1 of 2018 to October 31st of 2020. During that tenancy, John Schutt hired her to do some work on some investment properties, and she did help with those renovations. In 2020, she failed to pay rent. She failed to pay rent in June, so March, April, and June of 2020. Now, there was an agreement that was reached that she was current on her rent as of June of 2020, but then she thereafter failed to pay again in July, August, and September of 2020. A 3-day notice was provided in August of 2020, and then a forcible detainer petition under Chapter 61 was filed on September 11th of 2020. This petition specifically asked for late fees. The late fees in the petition were for $1,750 and for ongoing fees which may accrue during the action. There was also an amended petition filed in March of 2022 that also asked for late fees and ongoing late fees during the action. Now, before the district court, there were counterclaims filed by Foster, including a claim for punitive damages. So normally under a landlord-tenant action, you would go to trial within 14 days. That did not happen here. It took from September of 2020 to March 2nd of 2023 for this case to get to trial. And then on May 30th of 2023, the district court issued its journal entry, its ruling. It was 91 paragraphs and 16 pages, a very well thought out opinion, which is what we're asking the court today to affirm. The district court found that Schutt and Foster had agreed to the terms of the lease. What the district court did was they found that rent was owed $5,700 of rent, and then they added late fees for Foster to pay in the amount of $20 a day from the time of the unpaid rent to the time of the journal entry of judgment, which was 1,062 days of late fees for the time of rent, which was $21,240 in late fees. But what the court did was they essentially canceled out each other's judgments. Then they found that Schutt owed Foster for a security deposit. So the total amount that was owed, including the late fees, was, the court then found that Schutt owed Foster $17,868 for unpaid invoices. So what the court did was they offset the judgments. And so a total of $544.98 was owed from Schutt to Foster. So the court found Schutt owed Foster for unpaid invoices. They found Foster owed Schutt for rent and late fees. What's on appeal is essentially the late fees that were awarded. Now, this is a case where the district court carefully considered all of those factors, and we're asking this court to affirm the district court decision. The Court of Appeals found the late fees in this case were unconscionable pursuant to KSA 58-2544. Now, that statute, there's two issues with regards to the Court of Appeals ruling. Number one, they found it unconscionable, but KSA 58-2544B specifically states if unconscionability is put into issue by a party or by the court upon its own motion, the parties shall be afforded a reasonable opportunity to present evidence as to the setting and the purpose and effect of the rental agreement.
Can I ask you a question? Maybe jumping before we get to the merits, which you're kind of talking about now in terms of what the statute does or doesn't require. But I understood your first argument to be that that there's a question about preservation and whether or not the Court of Appeals panel properly even reached this statutory question of unconscionability, right?
Yes, yes.
And I guess, and the panel relied on a couple of different exceptions, but our precedent, has held that those exceptions do not apply when we have an undeveloped record or the issue requires further factual development. And that seems to be your argument here, that you need more information to rule on unconscionability. But the reason why that's the case is tied to the merits, it seems to me, because the Residential Landlord Tenant Act has this provision that you just referenced that gives you an opportunity to put on evidence before an unconscionability ruling is made, or that's your interpretation of the statute. So it seems like we're in this weird situation where, right, we need further factual development, but the reason why we do is tied to the merits. So don't we just have to get to the merits here as to whether or not at least you had a right to an evidentiary hearing?
Yeah, so the issue, so what we would ask the court to do is to remand it to the district court with regards to that unconscionability issue.
As opposed to saying that the panel erred altogether and even getting there and we shouldn't even go any further?
No, that was our other issue, was that the issue was not preserved. It's not properly before the Court of Appeals. It wasn't raised with the district court at all with regards to unconscionability and the lease and late fees. Further, in appellant's initial brief, under Kansas Supreme Court Rule 6.02A5, you're supposed to pinpoint cite to where each issue is raised in the record, and if it wasn't, why it was properly before the court. That was not done in the initial brief before the Court of Appeals. So our argument was that it was not properly preserved and it was not properly before the Court of Appeals with regards to that issue. Now, it was addressed in the reply brief in the Court of Appeals, with the Court of Appeals reply brief, and that was the case in Estate of Broderick, and the Court of Appeals found that exceptions 1 and 2 from Broderick applied, which was, it was a newly asserted theory or question of law arising on proved or admitted facts, and number 2, that it was a consideration of theory. The consideration of the theory is necessary to serve the ends of justice or to prevent the denial of fundamental rights. Again, here the issue is this could have been raised under the Kansas Landlord Tenant Act. The unconscionability statute deals with when the leases were made. It is an issue that could have been raised at the district court. Furthermore, what the Court of Appeals did was limit the late fees to when the tenant was in possession of the property, and said once she wasn't in possession, well, the lease doesn't allow for late fees anymore, which was not the case. There was nothing in the lease that said late fees ended when the tenant left the property. Further, that issue was not raised with the district court, that the late fees should be limited to when the tenant was in possession of the property.
Is there a distinction or any difference between the application of our exceptions to preservation when the issue is raised for the first time in a brief versus a reply brief?
Is there any distinction? Well, just reading the rule as it's written, it says in the appellant's brief.
Right, but the prudential exceptions to issues raised for the first time on appeal typically, at least, apply when an appellant raises an issue for the first time in their initial brief. I'm just wondering if you found any case law or any discussion about this is somewhat unique in that it's not only that it wasn't raised that it wasn't raised in the district court, it also wasn't raised on appeal until the reply brief.
Yes, that's correct.
And does that make any difference?
Well, the first factor is it wasn't raised below. right? So the Court of Appeals, it wasn't preserved for appeal. Then it's just an added factor that it wasn't raised for the first time in the reply brief. I
Do you think-
don't have a case on precedent that,
Okay.
I just have the Kansas Supreme Court rule with regards to the briefs. But yeah, our argument was that it was not properly before the Court of Appeals. And should not, and had, should not have been heard on that basis. So yes, so what the Court of Appeals did was they heard the case. We believe they did not have, it was not properly preserved and it should not have been heard. But they erred by limiting the late fees for when the tenant was in the rental property, which is, not what the lease did. And with regards, that's the, I guess, legal precedent that that is an issue of public importance. In this case, the lease contained a holdover provision. Now, it was expired, but under Kansas law, as cited in our supplemental brief, when a tenant holds over with the consent expressed or implied of the landlord, the law implies a continuation of the original tenancy upon the same terms and conditions.
But isn't that the whole point, going back to what you said, is that in the lease, it didn't specifically say that it was limited to, that late fees would not accrue once the person moves out?
Yes,
Okay.
the lease.
But isn't that the whole point, that literally under that lease, the late fees never stop accruing? It could be 40 years. And if you haven't paid the rent that's due, and I don't know whether you subtract the late fees first, whether it's like a credit card where you do the interest first or your mortgage, but this, under the lease, the late fees could accrue for the rest of a tenant's life. Isn't that true? I mean, that's the whole unconscionability argument.
So chapter 61 is set up so that does not happen, right? Under KSA 613807A, a forcible detainer action is supposed to go to trial within 14 days. Okay, that's in 14 days after the appearance stated in the summons. So once you have that trial, the late fees are determined, at that date. And so that just didn't happen here. It took 2.5 years for us to get.
But where does it say that once judgment is entered, if you don't pay on the judgment, aren't late fees still accruing under that lease?
So normally and my time's almost up, but in chapter 61, so you have the trial, the late fees are in the journal entry. And then after that journal entry, it's post-judgment interest. So, but here we didn't have a journal entry instead of going to trial.
My question is that under that lease, isn't it ad infinitum? Late fees continue to accrue even after, I don't understand. I mean, isn't that the whole point? That it's unconscionable because late fees never stop accruing, no matter if there's a judgment for the old late fees, but late fees will still accrue under your position.
So the position of under chapter 61 is once there's a trial, I mean, the late fees stop accruing.
Where does it say that?
It doesn't say that in the so it says that KSA with regards to late fees stop accruing.
Yeah.
That's just the normal practice under landlord tenant law, is it goes in, the late fees go, so the petition asks for late fees. And once there's a trial, there's a journal entry granting whatever amount of late fees apply. Usually that trial's within 14 days. And after the journal entry, it's usually post-judgment interest.
Right, but that's, the statute doesn't prohibit, I mean, there could be, under the lease.
Well, when there's a ruling under the petition that terminates that action, and then it's post-judgment interest thereafter.
Then you could file a new complaint saying, and you've never paid these under the judgment, and therefore you need
I think that would be res judicata, because in the petition, you're asking for late fees, accruing $20 a day. Like I said, normally it goes to trial within 14 days, and you have the trial, the late fees are.
You're talking about a practice. I'm talking about the lease, what the lease says. And the statute doesn't prohibit that.
That's a possibility, but that's not really, I guess, in practice how it really plays out in chapter 61.
Well, if it did, and late fees continue for 40 years, if those late fees reasonably approximate actual losses, then maybe it's not a problem. But isn't your point that we don't know that because we never had the opportunity to put on evidence?
Yes, that's correct. We didn't, it was never raised. It was never raised below. So there was never an opportunity to put on evidence with regards to that. And I mean, a judgment's not collectible after 5 years in Kansas, so it's not practicality that can't really be collected in an infinity. You know, there's statutes under Chapter 61 that essentially prohibit that.
May it please the court, Eric Kraft here on behalf of the tenant, Sherri Foster. And I would agree with Justice Standridge. These fees could go on forever. And in fact, the limited actions court or the limited action statutes allow a bifurcated proceeding as to possession versus rent. Now, we prohibit landlords from receiving attorney's fees. But a savvy landlord is going to ask for possession, and before the statute runs 5 years later, they're going to file an action and say, I need $20 a day for late fees for the last 5 years. And that's going to cover the expenses of attorneys. We have so many statutes within the Kansas Residential Landlord and Tenant Act that protect tenants. They protect tenants. We can't ask for, we can nullify a settlement that violates the act. We can modify the lease when conscionability comes into play. We can impose a penalty on the landlord for failing to timely reserve a security deposit. I have a page of statutes here. But we can assess $20 a day for 3 years which equates to 128% interest rate on the judgment after the property has been relinquished and after the rent had been paid by the offset judgment.
I mean, the simple question is, why didn't you raise all those issues at the district court level?
Because nobody asked for $21,240 in late fees, Judge. The only things that were asked were $5,700 in rent in the original petition, and I believe $1,750 in late fees in the original petition.
The petition also asked for ongoing late fees, correct?
That is correct.
Okay.
Now, the ongoing late fees were not spelled out, but 2 years later, I believe approximately 2 years later, when an amended petition was filed, the exact same late fees were asked, the exact same rent was asked. $5,700, $1,750 in late fees.
I still don't understand your answer. It seems to me if it's in the original petition for late fees, then it's in play. And so all of your defenses, the affirmative defenses that the tenant would have come into play, and this would be one of them, that you're not entitled to this because it's unconscionable under the law.
That
the late fee.
Absolutely.
So why wasn't it raised at the district court level?
Because nobody in a limited actions court, there is no pretrial order. There is no final pretrial order that says this is exactly what we're asking for. What we have is a petition that asks for, that is required to say that which the landlord wants. It doesn't say something that the landlord wants. It says it has to specify the amount that the landlord wants. We have a petition that says $1,750 in late fees at the beginning of the action. We have a petition 2 years later that says $1,750 in late fees at the same amount. And nobody addressed late fees at the trial.
So are you saying then that the $1,750 at that point, since that's what they asked for, you didn't believe that that was unconscionable? It was only when the district court raised it from $1,750 to $21,000 that it became unconscionable?
That is absolutely correct. What we did was it was a little bit of rope-a-dope. You lull the tenant into believing they're only going to ask for $1,750 in late fees. And then they get 3 years of late fees at $21,240. Nobody raised the issue of being entitled to $21,240. And the district court put it in its order for the very first time, which is why it was appealed. And this is the sole issue on appeal.
But is the statute, the unconscionability question decided based on the circumstances at the time of formation?
The statute does say that. However, the district court still has the inherent ability under common law to limit unconscionability as it's applied. So if we go back and we find $20 a day is not unconscionable when the lease was entered, but as it was applied to reach 128% interest rate on these fees, on these rental agreement, what we're saying then is the court doesn't have the ability to modify the application of what has become unconscionable, and I don't think the law supports that. I don't think that the law supports that at all. And in fact, if the court is modifying as applied, then KSA 582544A doesn't even come into play.
How would the common law come into play when the statute moves in and describes the various rights that the parties have? I mean, the legislature can pass statutes that override the common law.
Because the common law is not overridden here, Judge. It says that if you want to contest the late fee as unconscionable as written, you have to have a hearing, you have to bring it up. It doesn't say anything about as applied. It doesn't limit the court to saying you can't modify the application of a fee. And in fact, it really specifies that the implication of a lot of these statutes are that the court does have the ability to modify unconscionable actions that result from a trial like this.
So that may, go ahead.
Go ahead.
You've explained, I think, in response to Justice Biles' question, why you didn't raise the unconscionability issue at the trial court. Why did you also not comply with Rule 6.02A5 by invoking an exception in your brief?
That was my error. I will perfectly admit that. However,
And doesn't our case law say, I mean, we have a line of cases from Williams to Godfrey that basically says litigants ignore the requirements of 6.02 at their own peril.
it does say that, Judge. However, in Russell versus Trainer Investments, which is a 2020 case from this court, the district court, acting sua sponte, raised an issue with its findings of fact and conclusions for the first time. And this court found that it was properly raised at the trial court level, and pinpoint references by the appellate satisfied Rule 6.02A5.
But that's in a case where the issue was raised. Here we have an issue that wasn't raised.
No, that's a case that it was not raised at the trial court level. The district court, in its findings of fact and conclusions of law, addressed the issue, like here, for the first time with its judgment. The application of the $21,240.
Your argument is that if the issue is decided, that 6.02 doesn't apply?
No, I'm not.
In other words, you don't need it. You're arguing you don't need an exception to preservation. Is that your argument?
No, well, no, I think we complied with 6.02A5.
Well, the rule requires you to cite to where the issue was decided.
Yes.
And if your argument wasn't raised below, you have to invoke one of the exceptions to our preservation requirements.
Correct. And
You didn't do.
I addressed the sua sponte decision on page 3 of my original brief, and I discuss it on pages 11 and 12 of that brief, talking
I
about
understand that. but
how it was raised.
Do you agree that you did not invoke an exception until your reply brief?
I didn't need to invoke an exception. I didn't feel I needed to invoke an exception because the trial court had raised the issue.
Okay.
How did the trial court, oh, I'm sorry, Chief, go ahead. You were next in line.
No, if you're following up, can, because mine's,
Well, I was just curious how the how did the trial court raise unconscionability under this statutory provision?
The trial court didn't raise unconscionability.
Okay.
It applied it unconscionably. The appeal was the application of the $21,000 in late fees. And my argument was it was unconscionable. In my original brief, we discussed it in my original brief. An entire section of my brief was devoted to it. An entire section of the appellee's brief was devoted to it. Yet I believe that they've waived the argument to get a hearing for unconscionability to determine whether or not this is unconscionable by never bringing it up when they're arguing against unconscionability.
But the statute, though, wasn't cited until the reply brief.
That is correct.
Okay.
But that is the only statute in the Landlord-Tenant Act that involves unconscionability, mentions unconscionability whatsoever. So we didn't specify the number, but it was discussed. And as being discussed, nobody from the appellee's argument said, but if you do find it unconscionable, you need to give us a hearing. They didn't say that in the Court of Appeals brief. They didn't say that in their suggestions back to the Court of Appeals. It was never brought up until they lost the appeal at the Court of Appeals.
and
I'm sorry.
nobody asked at the trial court level for reconsideration of the judgment or an amended judgment.
No.
So, as I understand your argument, and stepping back just a minute, because the statute does talk about unconscionable when made. And am I gleaning from your comments that you do not necessarily think $20 a day in terms of the amount is unconscionable, that what makes this unconscionable is the gap in the lease that doesn't mention a termination upon change of
That-
possession or any other termination date?
That would be my argument, Judge, because if this were a case that $20 a day were applied for 10 days and we're talking about $200, it wouldn't be here. Nobody is going to appeal a case for $200. Here, however, that was left to run for 3 years and allowed $21,240 in fees, not in rent. That's just fees. And as much as we try to protect the tenants in the landlord-tenant arena, this smacks that completely upside down.
So in a way, you're arguing that there is an argument that it was unconscionable at formation without that limitation in the agreement.
I'm arguing that we don't need to get there.
Yeah.
Because $20 a day, if it were shorter, it wouldn't be an issue. But as it was applied, and I know that in practice, we have a new judge in Chapter 61. The former judge would limit that as a matter of practice. That's what he would do. And it never came up. However, here, there was no limitation. And I also, why until the end of judgment? Why until the judgment is rendered? Why not until the end of possession? Why not until the underlying debt was paid by the offset judgment? It is, had we, again, you could wait for 5 years to sue for the lease and rake in an enormous amount of penalty.
Were the amounts owed to Miss Foster at this simultaneously with the time period when she failed to pay the rent? I mean, when did those
Yes.
accrue and become payable?
When Ms. Foster moved into this apartment, or this house, actually, she was also simultaneously hired to be a construction manager for two other houses owned by the appellee, as well as to perform construction management on the house that she was living in. So the payments were back and forth. She was submitting bills to the landlord was paying those bills, she was paying her rent. 2020, COVID happened, everything went south. The landlord forgave some rent because he couldn't pay, and he applied it to some of what Ms. Foster owed, but only applied that to 3 months. And after that 3 months, she still could not pay her rent because she was not getting paid for these jobs. So she issued bills. He fired her from these construction management positions. And she was $5,700 short in rent.
So you're driving at what's been nagging at me about this case, which is it strikes me that the district court's decision was a Solomonic decision of a sort.
believe so,
And
yeah.
does that does that matter with the issues that are before us? It kind of seems like it maybe should, although I'm not certain that's right.
I think it does matter, and I would encourage this court to address it, because this is Ms. Foster's way of living. She knows the rules when she is performing these actions. She's going to bill him at an hourly rate. He's going to pay her at an hourly rate. Under the Kansas Landlord and Tenant Act, the appellee, Mr. Schutt, knows he's going to be limited as to what he can get. He can't get his attorney's fees.
When you sort of agreed with me, just to clarify, the way I was meaning that is the district court appears to essentially, the district court's judgment appears to me to essentially say, look, neither side has clean hands. You're bickering over all this stuff and you're both at fault. I'm just gonna cancel it out.
And equity shouldn't involve itself in a contract matter. If they had both clean hands, he didn't hold that in his ruling. I do believe it was a Solomonic decision. But he changed the rules at the end of the game, is what he did.
So it's your position is kind of like you can't do that.
Right.
Okay.
She did the work. He agrees that she did the work. He agreed that she was owed the money that she was owed, yet he imposed an egregious penalty to try to even things out and say, well, I don't like either party. I'm not going to give you everything you want, and he's just going to owe you $550 after all of this. Now, this court has the opportunity to instruct lower courts. I'm out of time, so I will thankfully, unless there are other questions, I can rest.
Seeing none. Thank you.
Thank you.
So the appellee believes there is no common law exception under the unconscionability statute. The statute 582544 specifically talks about limiting the application of any unconscionable provision to avoid an unconscionable result. So that is addressed in the statute. The issue is with regards to conscionability under the Landlord Tenant Act, it's when the lease is made. It's when the lease is made.
What would you respond to the argument that when the lease was made, the $20 per day was unconscionable because there was the lack of any cap or temporal limit?
Raise it below. It was in the lease, it was in the petition, they litigated it for 2.5 years, raise it in the district court. If that's, I do not believe it's unconscionable as written or when made. However, if the appellant felt that way, raise it with the district court.
Even though the amended complaint, which was 2 years later, asked for the same amount of money?
So
Even though
just
2
practice.
years at $20 a day should have been whatever.
The reason practical, it might just have been lawyering, he had changed the damages provision from $10,000 to $30,000. So with the late fees, it was the same in the petition and the amended petition, but it did say for ongoing fees. So that was very clear in the petition and the amended petition, that it was ask for late fees, ask for ongoing fees. So if if appellant believes it was unconscionable in the lease, raise it at the district court. I would say chapter 61 has provisions, so a situation like this doesn't happen. Like I said, mostly the trial's supposed to go to trial within 14 days. Further, under KSA 61-3807B, it says no continuance shall be granted unless the defendant requesting a continuance shall file a bond with good and sufficient security approved by the court, conditioned for the payment of all the damages and rent that may accrue if judgment is entered against the defendant. So this really isn't a case about unconscionable late fees in a lease. It's chapter 61 has provisions, so this doesn't happen. In this case, that no bond was paid for the back rent that was owed. That could have been paid into the court.
Now, this happened in the throes of COVID. What was the reason that it went 3 years instead of 14 days?
There was so there was a petition, there was counterclaims. In September of 2021, appellant filed a motion to assert punitive damages. There's another amended petition. So the fault of the delay in getting to trial was both parties' fault, was everyone's fault. There's many, like I said, counterclaims and requests for punitive damages. So the Landlord Tenant Act already has provisions and guidelines in place, statutes in place. So something like this doesn't happen.
Your argument is you can cut off the ongoing damages by posting a bond.
Yes, you post a bond for the rent that's owed, because the lease said until it's paid. And here, the district court, which we're asking this court to affirm, did balance out both sides, heard all the testimony, heard all the evidence, and decided everyone got penalized. Post-judgment interest was assessed, and the late fees were assessed. So both parties had, I guess, consequences from the delay in getting to trial. I think my time is up unless anyone has anything further.
Let me just ask you this.
Yeah.
If chapter 61 talks about the trial is supposed to happen in 14 days, which is supposed to cut off the late fees, then why isn't that kind of a dictate that that you only get late fees for the 14 days? Is it implicit within chapter 61 that?
I don't think it's implicit that you only get late fees for 14 days. It's just a reminder that it took so long to get to trial. So we have ongoing.
That's not what
fees that
I'm
are-
saying. I'm just saying if you're saying this whole thing shouldn't have happened because there's a chapter 61 says trial's supposed to happen in 14 days and then there would be a date certain when those late fees would end. That's your argument, right?
Or if it's past the 14 days, there's supposed to be a bond posted for the amount of past due rent and damages.
Okay, but you agree with the beginning that it's supposed to be the 14 days. I mean, what you're saying is there's a safety valve in there with this 14 days.
Yes. So here,
So what I'm saying is then why wouldn't that mean that the judge should only impose late fees for whatever time and 14 days?
because they didn't go to trial here in 14 days. They went to trial, took 2.5 years. So the lease
So the safety valve didn't work.
didn't work and there was no bond posted, which would have been the back rent that was due. So both of those things were not.
But the back rent that was due, then there was the counterclaim that she couldn't pay her rent because he never paid her.
Yes, there was a counterclaim, there was a petition, there was counterclaims for invasion of privacy,
Well, I think you're
punitive damages.
missing my point, but
Yes.
thank you.
Anything further? Okay, thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement.